Well, my learned brothers and sisters, this is Advocate P.A. Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is far. Today, I've selected a very good topic from criminal law, that is criminal conspiracy. Indian Penal Code, Section 120A and 120B, and the present law, Bharatiya Nyaya Sanhita 2023, Section 61, Subsection 1 and 2. Indian Evidence Act applicable is Section 10 and existing law, that is Bharatiya Nyaya Sanhita 2023, Section 8. Now Section 61, Subsection 1 and 2 defines criminal conspiracy. Now first let us see the ingredients of the offense. Number 1, that there should be an agreement between the persons who are alleged to conspire. And number 2, that the agreement should be for doing an illegal act, or for doing by illegal means an act which may not itself be illegal. Now, what is the evidence required? Prosecution should prove, number 1, that the accused agreed to do or caused to be done an act. Number 2, that such act was illegal or was to be done by illegal means. 3, that some overt act was done by one of the accused in pursuance of the agreement. Now, Evidence Act applicable. Bharatiya Sakshya Adhiniyam 2023, Section 8 deals with things said or done by conspirator in reference to common design. It reads, where there is reasonable ground to believe that two or more persons have conspired together to commit an offense or actionable wrong. Anything said, done or written by any one of such persons in reference to their common intention after the time when such intention was entertained by any one of them is relevant, as against each of persons believed to be so conspiring, as well for the purpose of proving the existence of the conspiracy, as for the purpose of showing that any such person was a party to it. Now there is one very good illustration useful to understand the provisions of the case as well as how to prove the case and how to allege the allegation. Illustration. Reasonable ground exists for believing that a person has joined in a conspiracy to wage a war against the state. That facts that B person procured arms in Europe for the purpose of conspiracy. C person collected money in Calcutta for a like object. D person persuaded persons to join the conspiracy in Mumbai. E person at Singapore the money which C person had collected at Kolkata and the contents of letter written by H person giving an account of the conspiracy are each relevant both to prove the existence of the conspiracy and to prove a person's complicity in it. Although he may have been ignorant of all of them, and although the persons by whom they had done were the strangers to him, and although they may have taken place before he joined the conspiracy or after he left it. This is a very good example. The gist of the conspiracy then lies not in doing the act, or effect the purpose for which the conspiracy is formed, nor in attempting to do them, nor in inciting others to do them, but in the forming of the scheme or agreement between the parties. Agreement is essential. Mere knowledge or in discussion of the plan is not per se enough. An agreement to effect something which in itself may be indifferent or even lawful by unlawful means amounts to conspiracy. Now, according to definition of criminal conspiracy in section 61, subsection 1, one person alone can never be held guilty of criminal conspiracy for the simple reason that one cannot conspire with himself. It requires two persons. In one of the case, the law lord stated, I quote, if two or more persons agree together to do something contrary to law or wrongful or harmful towards another person, or to use unlawful means in the carrying out of an object not otherwise unlawful, the persons who so agree commit the crime of conspiracy. Like most crimes, conspiracy requires an act, that is actus reus, and an accompanying mental state, that is mens rea. So actus reus and mens rea both are required. The agreement constitutes the act, and the intention to achieve the unlawful objective of the agreement constitutes required mental state. Conspiracy criminalizes an agreement to commit a crime. The law punishes conduct that threatens to produce the harm as well as conduct that has actually produced it. Conspirators may be tried and punished for both the conspiracy and the completed crime. Conspiracy can be proved by circumstantial evidence also. Mere circumstantial evidence to prove the involvement of the appellant would not be sufficient to meet the requirement of criminal conspiracy, and a meeting of mind to form a criminal conspiracy has to be proved by placing, I emphasize, the substantive evidence, by substantive evidence. Direct evidence to prove conspiracy is rarely available. Therefore, circumstances proved before, during, and after occurrence have to be considered to decide on the complicity of the accused. The essence of criminal conspiracy is an agreement to do an illegal act. Such an agreement can be proved either by direct evidence or by circumstantial evidence. Conspiracies are not hatched in the open by their nature, they are secretly planned. The lack of direct evidence relating to conspiracy has no consequence. The most important ingredient in the offense of conspiracy is the agreement between two or more persons to do an illegal act. The illegal act may or may not be done in pursuance of the agreement, but the very agreement is an offense and is punishable. Conspiracy requires some kind of physical manifestation or agreement. Express agreement, however, need not be proved, nor actual meeting of two persons is necessary, nor is it necessary to reveal the actual words of communication. The evidence as to transmission of thoughts sharing the unlawful design may be sufficient. The law does not require that the act of the agreement take any particular form, and the fact of agreement may be communicated by words or conduct. A tacit understanding between the conspirators as to what should be done is sufficient. Whether no meeting of mind that cannot be conspiracy. A conspiracy is not merely a concurrence of wills, but a concurrence of resulting from agreement between the two. This agreement is the rock bottom of the offence under section 120A of IPC, present law, BNS section 61 subsection 1. Connection cannot be sustained when the evidence against the accused is flimsy, unreasonable, and does not firmly establish his guilt. Conspiracy is a substantial evidence and has nothing to do with abatement. For example, if two burglars should decide independently, not common intention, to burgle the same house on the same night, their independent decisions would not constitute the conspiracy. Now, abatement. Bharatiya Nyaya Samhita 2023, Section 45, Subsection B. Indian Penal Code, Section 107, Subsection B. In this, there is written one word, conspiracy. There is Section 45B, abatement of a thing. Read out. A person abets the doing of a thing who engages with one or more other persons or persons in any conspiracy for the doing of that thing if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing. Now, comparison legal analysis. Section 107, subsection B of CRPC and Section 120A of IPC versus present law, Bharatiya Nyaya Samhita 2023, Section 45, Clause B, and BNS Section 61, subsection 1. What is the distinction between these two? Only one word, conspiracy has come, that is why I am just making comparison. Distinction in brief. A charge under Section 107 or 109 of IPC and BNS Section 45B and 49 should therefore be in combination with substantive evidence. Whereas the charge under Section 120A and 120B, Bharatiya Nyaya Samhita 2023, Section 61, subsection 1 and 2, could be an independent charge, conspiracy is substantive evidence, and has nothing to do with abatement. Agreement is the rock bottom of the offence under Section 61, subsection 1 and 2 of BNS. Now, Section 107B IPC and BNS Section 45B. In their combination of persons or an agreement between them is not enough. An act or illegal omission must take place in pursuance of the conspiracy and in order to the doing of the thing conspired for. Whereas in IPC Section 120A and Section 120B and in BNS 2023 Section 61, Section 1 and 2, the mere agreement is enough. If the agreement is to commit an offence, then there can be independent charge. It is not like abatement. Now, two important legal provisions, that is regarding 195 CRPC, the present law, Bharatiya Nagrik Suraksha equivalent to that, is Section 215. Another legal provision is CRPC Section 196 or Section 2 and BNS Section 217, which talks about sanction. Before paying the charge, London magistrate or a police officer has to see the provisions of Section 215 of BNS or Section 196 of Section 2 of CRPC and present law Section 217 of BNS. 215 and 195 CRPC, it talks the same thing. what for it is? Prosecution for contempt of lawful authority or public servants for offences against public justice and for offences relating to documents given evidence. Now, Section 217 of BNS and Section 196 of CRP talks the same thing about sanction. Prosecution for offences against state and for criminal conspiracy to commit such offences. Now, what is to be kept in mind? Now, first let us see Section 195. Equivalent law, present law is Bharatiya Nagarik Suraksha Sanhita, Section 215. What is the provision? Where a charge of conspiracy to forge documents in court is filed, emphasize documents in court, the bar of Section 195, that is BNS Section 215, will operate, and action can only be instituted on the basis of court complaint. The requirement of court complaint cannot be waived merely because some of the offences mentioned in the charge sheet can be proceeded by means of other than a court complaint. So, as per provision Section 215 of BNS, for documents presented in the court complaint is a must. If court complaint is not there and FIR is there, then you can very well go for quashing before High Court. Now, another legal provision is Section 196 of Section 2, equivalent Bharatiya Nagarik Suraksha Sanhita 2023, Section 217. In short, BNSS, Section 217. Legal provision. It provides that no court shall take cognizance of any criminal conspiracy punishable under Section 120B, that is BNS Section 61 subsection 2, unless the state government or the district magistrate has consented in writing to the initiation of the proceedings. However, such consent will not be required when such consent is not required. The criminal conspiracy is to commit an offence punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upwards, then consent is not required. Now, another provision, if the criminal conspiracy is one in which the provisions of Section 195 CRPC or BNS Section 215 applies. If this 215 BNS is applied, then consent is not required. So, here also, where there is provision of 215 not applied, then you can go for quashing. Then consent is not required. Before granting consent for initiating criminal proceedings, the state government or the district magistrate may order a preliminary investigation by a police officer who shall have the power conferred to him under Section 155 subsection 3 of CRPC, present law, Bharatiya Nagarik Suraksha Sanhita 2023, Section 174 subsection 3. Section 174 subsection 3 of BNS reads as under. Any police officer receiving such order may exercise the same powers in respect of the investigation except the power to arrest without warrant as an officer in charge of police station may exercise in a cognizable office. Now, this is the end of the video. Hope you have got some valuable information from this video. Must have enjoyed this video. See you in the next video. Thank you for participating in this video. Thank you. Thank you. Thank you. Jai Shri Ram.